The armed assault in a dwelling house, 265-18 large A. As to Lisa, what is the felonious intent?
The felonious intent, Your Honor, would be burglary, would be,
Burglary to what extent? To confront an occupant therein?
no, just to break and enter in the nighttime with intent to commit a felony.
Isn't that pretty much subsumed in that indictment?
Is it subsumed in that indictment?
I'm concerned about bootstrapping. The classic armed assault is when you're going to rob somebody.
Right, but that could be, I think that would be after a verdict, then it may be subsumed in another one. If they only convict on that and they don't convict on something else, then that would stand. If they convict on both, then we'd have to argue, but is that subsumed in the other conviction?
Let's see what happens. Now, use of a firearm in the commission of a felony. What's the felony?
It could
Now,
be
as to Lisa,
ABD
that's pretty simple.
Could be ABDW, it could be,
Well, isn't the firearm the DW?
well, he had a knife, he had a rifle, he, so it doesn't have to be that.
Let's see what happens. I think there's a plethora of indictments that, quite frankly, are gumming the case up. All right, we ready for the jury? Let's bring down the jurors, please. I'm sorry? Thank you.
Yeah, this is just opposite.
Please be seated.
First degree by two theories. One, premeditated murder. And two, murder with extreme atrocity or cruelty. To find the defendant guilty on either of the two degrees of murder, you must be unanimous as to the particular theory. That is, all of the deliberating jurors must agree that the Commonwealth has met its burden of proving every required element of that particular theory that you are then considering beyond a reasonable doubt. On your verdict slip, you will find not guilty, lack of criminal responsibility, guilty, first-degree murder, with two sub-boxes thereunder, one for deliberate premeditation, one for extreme atrocity and cruelty, guilty, second-degree murder, guilty of manslaughter. If you find the Commonwealth has proved every element of deliberate premeditation, and you find it unanimously beyond a reasonable doubt, then you would check that box. It is not exclusive if you find deliberate premeditation that you cannot also consider extreme atrocity and cruelty. To the contrary, you may consider both theories. But to find the defendant guilty under either theory or both, as to the theories or theories for which you find guilt, that theory must be unanimously determined beyond a reasonable doubt by all of your number. If you are unable to agree unanimously that the Commonwealth has met its burden to prove beyond a reasonable doubt either of these theories of first-degree murder, you shall consider whether the Commonwealth has proved the defendant guilty beyond a reasonable doubt of murder in the second degree. If you are unable to agree unanimously that the Commonwealth has met its burden to prove beyond a reasonable doubt that the defendant is guilty of murder in the first degree or murder in the second degree, you shall consider whether the Commonwealth has proved the defendant guilty beyond a reasonable doubt of the lesser offense of manslaughter. I'm going to begin by instructing you as to the elements of the two theories of murder in the first degree. Then I will turn to second degree and then to manslaughter. First, as to murder with deliberate premeditation. To prove the defendant guilty of murder in the first degree with deliberate premeditation, the Commonwealth must beyond a reasonable doubt the following. One, that the defendant caused the death of Lisa Trubnikova. Two, that the defendant intended to kill her. That is, the defendant consciously and purposefully intended to cause her death. Three, that the defendant committed the killing with deliberate meditation. That is, he decided to kill after a period of reflection. Those are the three elements the Commonwealth must prove beyond a reasonable doubt for murder in the first degree by deliberate premeditation. If the Commonwealth proves all three elements beyond a reasonable doubt, but does not prove beyond a reasonable doubt the defendant's criminal responsibility, then the verdict is not guilty by lack of criminal responsibility. If the Commonwealth fails to prove any one of the three elements that I just gave you for first-degree murder, then it's not guilty in its simple form. Let's look at these three elements in greater detail. The first element is that the defendant caused the death of Lisa Trubnikova. A defendant's act is the cause of death where the act, in a natural and continuous sequence, results in death, and without which death would not have occurred. The second element is that the defendant intended to kill Lisa. That is, the defendant consciously and purposefully intended to cause her death. The third element is that the defendant committed the killing with deliberate premeditation. That is, that he decided to kill after a period of reflection. Deliberate premeditation does not require any particular length of time of reflection. A decision to kill may be formed over a period of days, or of hours, or even seconds. The key is the sequence of the thought process. First, a consideration as to whether to kill. Second, the decision to kill. And third, the killing resulting from that decision. There is no deliberate premeditation where the action is taken so quickly that the defendant takes no time to reflect on the action and then decides to do it. In deciding whether the defendant intended to kill the victim and whether he formed that intent with deliberate premeditation, you may consider any evidence that the defendant suffered from a mental impairment. A defendant may form the required intent to act with deliberate premeditation even if he suffered from a mental impairment. But you may consider such evidence in determining whether the Commonwealth has proved the elements I've given. In other words, it's permissible if you conclude that a defendant is criminally responsible, that is, the Commonwealth has proved beyond a reasonable doubt criminal responsibility, but it is still permissible for you to consider whether the mental disease or defect prevented the government from proving beyond a reasonable doubt the intent to kill or the premeditation. If the Commonwealth has proved the three elements as I've given them to you for deliberate premeditated murder and has proved criminal responsibility, you may find the defendant guilty under that theory of murder, if they've proved it unanimously beyond a reasonable doubt. Let us turn to murder with extreme atrocity or cruelty. You shall consider this theory of murder in the first degree regardless of whether or not you find the defendant, you find the Commonwealth has proved murder in the first degree with deliberate premeditation. To prove the defendant guilty of murder with extreme atrocity or cruelty, the Commonwealth must prove the following three elements beyond a reasonable doubt. First, that the defendant caused the death of the victim. Second, that the defendant either, and this element has three prongs to it, either intended to kill the victim or intended to cause grievous bodily harm to the victim or intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. And the third element is that the killing was committed with extreme atrocity or cruelty. Let me break those elements down slowly. The first element, that is causing the death, is identical to my prior discussion in that regard. A defendant's act is the cause of death where the act is a natural and continuous sequence, that any natural and continuous sequence results in death and without which death would not have occurred. The second element is that the defendant intended to kill Lisa or intended to cause her grievous bodily harm or intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. As you can see, this second element has three sub-elements, or what I might call three prongs, and the Commonwealth satisfies its burden of proof on this second element if it proves any one of the three prongs beyond a reasonable doubt. The first prong, that the defendant intended to kill, is the same as the second element of murder in the first degree by deliberate premeditation. The second and third prongs are different from any element of murder in the first degree with deliberate premeditation. The second prong is that the defendant intended to cause grievous bodily harm to Lisa. Grievous bodily harm means severe injury to the body. The third prong is that the defendant intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. Let me help you understand that third prong. You must first determine whether the defendant intended to perform the act which caused Lisa's death. If you find that he intended to perform the act, you must then determine what the defendant himself actually knew about the relevant circumstances at the time he acted. Then you must decide whether, under the circumstances known to the defendant, a reasonable person would have known that the act intended by the defendant created a plain and strong likelihood that death would result. In deciding whether the defendant intended to kill, intended to cause grievous bodily harm, or intended to do an act which in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result, you may consider any credible evidence that the defendant suffered from a mental impairment. The third element of first-degree murder by extreme atrocity or cruelty is that the killing was committed with extreme atrocity or cruelty. Extreme atrocity means an act that is extremely wicked or brutal, appalling, horrifying, or utterly revolting. Extreme cruelty means that the defendant caused the person's death by a method that surpassed the cruelty inherent in any taking of a human life. You must determine whether the method or mode of killing is so shocking as to amount to murder with extreme atrocity or cruelty. The inquiry focuses on the defendant's action in terms of the manner and means of inflicting death and on the resulting effect on the victim. In deciding whether the Commonwealth has proved beyond a reasonable doubt that the defendant caused the death of the deceased with extreme atrocity or cruelty, you must consider the following factors. I'm going to give you 7 factors. You must consider the 7 factors, and there must be at least one of them that has been proved beyond a reasonable doubt to form the basis for a finding of extreme atrocity or cruelty. First factor, whether the defendant was indifferent to or undertook pleasure in the suffering of the deceased. Second factor, the consciousness and degree of suffering of the deceased. Third factor, the extent of the injuries to the deceased. Fourth factor, the number of blows delivered. Fifth factor, the manner, degree, and severity of the force used. Sixth factor, the nature of the weapon, instrument, or method used. And the seventh factor, the disproportion between the means needed to cause death and those employed. The seventh factor refers to whether the means used were excessive and out of proportion to what would be needed to kill a person. You cannot make a finding of extreme atrocity or cruelty unless it is based on one or more of the 7 factors I have just listed. You may consider the defendant's mental condition at the time of the killing, including any credible evidence of mental impairment, in determining whether the Commonwealth has proved beyond a reasonable doubt that the defendant committed the killing with extreme atrocity or cruelty. If you are unable to agree unanimously that the Commonwealth has met its burden to prove beyond a reasonable doubt either first-degree murder with premeditation or first-degree murder with extreme atrocity and cruelty, then you shall consider whether the Commonwealth has proved the defendant guilty beyond a reasonable doubt of murder in the second degree. In order to prove murder in the second degree, the Commonwealth must prove the following elements. 1, the defendant caused the death of Lisa Trubnikova. 2, the defendant either intended to kill Lisa or intended to cause grievous bodily harm to her or intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. The requirements of proof for murder in the second degree are the same as for murder in the first degree with extreme atrocity or cruelty, but without the element that the killing was committed with extreme atrocity or cruelty. And again, one may consider any mental disease or defect relative to that second element of murder in the first degree. If you have a reasonable doubt as to whether the Commonwealth has proved murder in the first degree under either of its two theories, or murder in the second degree, then you shall consider whether the Commonwealth has proved the defendant guilty beyond a reasonable doubt of lesser crime of manslaughter. To prove the defendant guilty of manslaughter, the Commonwealth must prove beyond a reasonable doubt two elements. One, the defendant intentionally inflicted an injury or injuries on the victim likely to cause death. And two, the defendant caused the death of the victim. Let us turn to the next alleged crime, which is armed assault with intent to murder. And as to that allegation, there are three separate indictments, Madam Forelady, hence there are three separate verdict slips. One is marked in parentheses below the title of the charge against Lisa Trubnikova, the next one against Anna Trubnikova, and the last against Jared McDonald. So as you consider each of the three, obviously the victim as to that particular indictment changes as you move from indictment to indictment. In order to prove assault with intent, armed assault with intent to murder, the Commonwealth must prove three elements beyond a reasonable doubt. First element, that the defendant assaulted the victim. Second element, that the defendant possessed a specific or actual intent to cause the death of the person assaulted. Third element, that the defendant was armed and accomplished the assault by means of a dangerous weapon. The first element the Commonwealth must prove beyond a reasonable doubt is that the defendant assaulted the named victim. An assault is defined as an attempt or offer by one person to do bodily injury to another by force and violence. An assault consists of an offer or attempt to commit a battery. The Commonwealth must prove beyond a reasonable doubt that the defendant intended to physically harm the alleged victim. Again, the victim varying from indictment to indictment to indictment. The Commonwealth must also prove that the defendant did an act toward the commission of inflicting physical harm on the alleged victim. In other words, the Commonwealth must show that the defendant did in fact attempt to do bodily harm to the named victim. Finally, the Commonwealth must prove the defendant had actual or apparent ability to inflict the bodily harm. That is the first element of assault. The second element the Commonwealth must prove beyond a reasonable doubt is that the defendant possessed a specific or actual intent to kill the person assaulted. Intent refers to a person's objectives or purposes. It must have had it in his mind to kill the person being assaulted. It involves concentrating or focusing the mind for some perceptible period. It's a conscious act, a deliberate act, with a determination in the mind to do. It's contemplation rather than reflection, and it must precede the intent, it must precede the act. The defendant must have specifically intended to kill the victim named in each of the indictments, going from indictment to indictment. This means that the defendant must have been shown to possess an actual subjective intent to kill. An intent merely to disable or scare off another is not a sufficient intent in this regard. The intent to do bodily injury or do serious bodily harm is also sufficient. It must be a specific intent to kill the person assaulted. It need not be proved by direct evidence, but may be proved by inference based on all of the circumstances attendant to the event. The third element is that the defendant must be armed with a dangerous weapon, and the assault accomplished by means of that dangerous weapon. As a matter of law, a loaded firearm or a loaded rifle is regarded under the law as a dangerous weapon. The Commonwealth must show that the assault was accomplished with that dangerous weapon. If the Commonwealth has proved all three elements as I have given them to you, you may find the defendant guilty of armed assault with intent to murder, again, moving victim to victim to victim through the three indictments. If the Commonwealth has established those three elements, they must also establish criminal responsibility beyond a reasonable doubt for you to find him guilty of armed assault with intent to murder. If the Commonwealth has established the three elements that I've given to you, but has failed to establish criminal responsibility beyond a reasonable doubt, then the proper verdict would be not guilty, lack of criminal responsibility. If the Commonwealth has failed to prove any one of the three elements that I've just given you, that is the assault, the intent to kill, and the armed and by means of the dangerous weapon, if the Commonwealth has failed to prove any one of those three elements, then the proper verdict is not guilty in its simple form. Again, as to the formation of the specific intent to kill, even if one finds the defendant criminally responsible, one can still consider the mental disease or defect as it may or may not, depending upon your finding, impact on whether the defendant had a specific intent to kill. The next set of charges are three indictments, again, varying according to the three individuals, Lisa, Anna, and Jared. The charge being aggravated assault and battery with a dangerous weapon, causing serious bodily injury. Assault and battery by means of a dangerous weapon, causing serious bodily injury, has been alleged. In order to find the defendant guilty of that allegation, the Commonwealth must prove to you unanimously, beyond a reasonable doubt, 4 elements, plus the added feature of proving criminal responsibility. The 4 elements being, first, that the defendant touched the person of the alleged victim without having any right or excuse for doing so. Second, that the defendant intended the touching. Third, that the touching was done with a dangerous weapon. And fourth, the touching thereby caused serious bodily injury. For the Commonwealth to prove beyond a reasonable doubt the first element, the Commonwealth must prove that it was a touching accomplished without any right or excuse for doing so. In that sense, it must be shown that the defendant consciously and deliberately intended the touching to occur. That is, it wasn't accidental, it wasn't negligent, it wasn't careless, it was an intentional touching without right or justification. touching must be accomplished by means of a dangerous weapon. As a matter of law, a loaded firearm or a loaded rifle is a dangerous weapon. The fourth element is that it must result in serious bodily injury. Serious bodily injury is defined as bodily injury that results in permanent disfigurement, loss or impairment of a bodily function, limb, or organ, or a substantial risk of death. If the Commonwealth has proved the four elements of assault and battery by means of a dangerous weapon causing serious bodily injury, as I've given them to you, and has proved criminal responsibility, you may find the defendant guilty. If the Commonwealth has proved the four elements, as I've given them to you, but not proved criminal responsibility, then the proper verdict is not guilty, lack of criminal responsibility. If the Commonwealth has failed to prove any one of the four elements that I just gave to you, then the proper verdict is not guilty. Prove any one of those four elements beyond a reasonable doubt, then the proper verdict is not guilty. The next set of indictments consists of two indictments for armed home invasion with a firearm. One indictment is as to Lisa, the other indictment is as to Anna. To prove the defendant guilty of the crime of armed home invasion with a firearm, the Commonwealth must convince you, the jury, of the following elements, four in number, beyond a reasonable doubt. First element, that the defendant unlawfully entered the dwelling place of another. Second element, that the defendant knew or had reason to know one or more individuals were present within the dwelling when entering, or that the defendant remained in the dwelling when he knew or had reason to know that one or more individuals were lawfully present therein. Third element, that the defendant was armed with a dangerous weapon, to wit, a firearm, at the time of entry. And fourth element, that the defendant used force or threatened the imminent use of force on any person within the dwelling house. Or alternatively, that the defendant intentionally caused injury to any person within the dwelling place. As to the indictment alleging Lisa, that injury or confrontation of threat must be as to Lisa. As to the indictment as to Anna, it must be as to Anna. With regard to the first element, the defendant must enter the dwelling. As to this indictment, an entry is the unlawful making of one's way into a dwelling. The Commonwealth must prove beyond a reasonable doubt that the defendant entered the dwelling unlawfully, without right, without authority. The Commonwealth must prove beyond a reasonable doubt that the defendant had no right of habitation or occupancy in that dwelling. The second element the Commonwealth must prove is that the defendant knew or had reason to know that one or more individuals were lawfully present in that dwelling, or in the alternative, that the defendant remained in the dwelling when he knew or had reason to know one or more persons were lawfully present therein. This requires, again, an examination as to the defendant's state of mind. There may be direct evidence in that regard, or you may infer a state of mind based on all of the circumstances surrounding the facts produced at trial. It is an examination as to what is in Mr. Loya's mind at the time, not what a reasonable person would have known. It is subjective to Mr. Loya. The third element is that the defendant was armed with a dangerous weapon, to wit, a firearm. A firearm is a weapon capable of discharging a shot or a bullet whose barrel length is less than 16 inches. A loaded firearm is a dangerous weapon by law. The fourth element the Commonwealth must prove beyond a reasonable is the defendant used force or threatened the imminent use of force on a person within the dwelling place. As to the first indictment in this category, that must be as against Lisa. As to the second indictment in this category, it must be as to Anna. Or, in the alternative, the Commonwealth may satisfy this element by proving beyond a reasonable doubt that the defendant intentionally caused injury to that individual. If the Commonwealth has proved all four elements as I have given them to you, plus proved criminal responsibility beyond a reasonable doubt, then you may find the defendant guilty. If the Commonwealth has proved the four elements as I've given them to you, but not proved beyond a reasonable doubt criminal responsibility, then the proper verdict would be guilty, lack of criminal responsibility. If the Commonwealth has failed to prove any one of the four elements that I just gave you beyond a reasonable doubt, then the proper verdict would be not guilty in its simple form. Moving to the next set of indictments, there are two. They charge armed assault in a dwelling house. It is distinct from the last crime that I discussed with you, the last set of allegations that I discussed with you, as to its elements. There is one indictment as to Lisa, one indictment as to Anna. For armed assault in a dwelling, the Commonwealth must prove four elements. First, that the dwelling was not the dwelling of the defendant. Second, that the defendant entered the dwelling. Third, that the defendant was armed with a dangerous weapon at the time of entry. And fourth, that the defendant made an actual assault on the individual who specified in that particular indictment. First element the Commonwealth must prove beyond a reasonable doubt is that the premises were not the dwelling house of the defendant. The Commonwealth may show by evidence that it was the dwelling of another. Second, the Commonwealth must prove beyond a reasonable doubt that the defendant entered the dwelling. No further explanation is needed as to that element. Third element that the Commonwealth must prove beyond a reasonable doubt is that the defendant was armed with a dangerous weapon. As a matter of law, a loaded firearm or a loaded rifle is a dangerous weapon. The fourth element the Commonwealth must prove is that an assault was made upon the occupant who was lawfully therein with the intent to commit a felony. I have already defined to you an assault, that is an attempt or offer by one person to do bodily injury to another by force and violence. And all that I said when I first defined assault applies to assault in this instance. Plus, the additional aspect that the assault must have been done with the intent to commit a felony. Murder is a felony. Assault by means of a dangerous weapon as to the other individual who may be lawfully therein would be a supported felony. Breaking and entering into the dwelling, if one breaks the door to get in and enters, would be an example of a felony. Commonwealth yet to prove beyond a reasonable doubt that when the defendant made an assault on the individual lawfully therein, he had in his mind to do a separate, distinct felony. A felony is any crime that is punishable by imprisonment in the state prison. I have given you the felonies that apply for your consideration. If the Commonwealth has proved all four elements as I have given them to you beyond a reasonable doubt, plus proved criminal responsibility beyond a reasonable doubt, then you may find the defendant guilty. If the Commonwealth has proved the four elements I've given you beyond a reasonable doubt, but has not proved criminal responsibility beyond a reasonable doubt, then the proper verdict is not guilty, lack of criminal responsibility. If the Commonwealth has failed to prove any one of the four elements that I have given to you beyond a reasonable doubt, then the proper verdict is not guilty in its simple form. When we are considering a specific intent, such as I just gave you, an assault with intent to commit an added felony, or in the past, as I've given to you, assault with intent to murder, and so on. When we're talking about a specific intent, what's in the mind of Loya at the time? You may consider in any of those instances mental disease or defect as to whether it does or does not negate proof beyond a reasonable doubt of the specific intent. Set of indictments are three in number. There are three separate indictments charging use of a firearm in commission of a felony. One is to Lisa, one as to Anna, one as to Jared. In that regard, the Commonwealth must prove five elements. First, that the defendant possessed or had under his control a firearm or rifle. Second, that the defendant possessed or had under his, that what the defendant possessed or had under his control met the definition of firearm or rifle. Third, that the defendant knew that he possessed a firearm or rifle. Fourth, that the defendant did so while in the commission of a separate felony. And five, there must be a nexus in terms of proximity and logical relation of that firearm to the defendant's other felonious activity. The first element. Did the defendant possess the item? Be it a firearm, be it a rifle. Second, did that item meet the legal definition? As to a firearm, I have given you the legal definition. As to a rifle, it is a weapon capable of discharging a shot or bullet through rifling technique in the barrel being longer than 16 inches or longer, excuse me. Third, that the defendant knew what he possessed was a firearm or rifle, as the case may be, as the instance may be. Fourth, that he did so while in the commission of a separate felony. Again, murder, breaking and entering, and are separate felonies with regard to the household. With regard to activities outside of the household, the retreat or escape from a felony committed in the household is part of that felony and may form the felonious basis for firearm during the commission of a felony. And the fifth element, that there must be a nexus in terms of proximity and logical relation between the separate felony and the defendant's possession of the firearm at that instance. Was his possession of the firearm knowing, in other words, it wasn't accidental, was it to facilitate the separate felony in any manner, at any stage, in preparation, in the course of, or the retreat from? There must be some connection between the separate felony and the firearm or rifle. There must be a logical relation between the possession of the firearm or rifle and the nature of the felony itself. It is this nexus or relationship is a necessary element of the offense and must be proved beyond a reasonable doubt. If the Commonwealth has proved the 5 elements as I've given them to you beyond a reasonable doubt, and has proved criminal responsibility beyond a reasonable doubt, then you may find the defendant guilty. If the Commonwealth has proved the 5 elements as I've given them to beyond a reasonable doubt, but not established criminal responsibility beyond a reasonable doubt, then the proper verdict is not guilty, lack of criminal responsibility. If the Commonwealth has failed to prove any one of the 5 elements that I just gave you as to this particular allegation beyond a reasonable doubt, then the proper verdict is not guilty in its simple form. The next set of indictments. There are 2 separate indictments of armed kidnapping causing serious bodily injury. In order to prove the charge, the government must prove 5 elements beyond a reasonable doubt. First, that the defendant acted without lawful authority. Second, that the defendant forcibly or secretly confined or imprisoned another individual within this state against her will. Third, that the defendant committed the offense against the other person's will. No. I don't know who wrote this one up. It wasn't me. Fourth, that the defendant committed the offense while armed with a dangerous weapon. Fifth, that by means of the dangerous weapon in the course of the offense, the defendant inflicted serious bodily harm on the victim. The first element the Commonwealth must prove beyond a reasonable doubt is that the defendant was acting without lawful authority. An act taken under lawful authority is something authorized, sanctioned by law, whether it is a parent with a minor child, whether it is a law officer acting pursuant to an appropriate warrant, whether it is a soldier acting in the time of war, and so on. Obvious examples of authority. The government must show the defendant acted without authority. The second element the Commonwealth must prove beyond a reasonable doubt is that the defendant forcibly or secretly confined or imprisoned the alleged victim within the Commonwealth. The word forcibly means to carry out with the use of force. One acts forcibly toward another if one compels, constrains, or obliges her to do something against her free will, or to remain confined against her free will. Force may be either actual or constructive. That is, it may be actual physical force applied against the victim. It may be a threat of violence sufficient to confine the victim. Secretly means to do something without the knowledge of others. Confining means to enclose within bounds or limits, to restrict, to shut up or keep in. Imprison means to detain in custody or to hold in restraint. Any restraint of a person's liberty is a confinement or an imprisonment. The third element the Commonwealth must prove beyond a reasonable doubt is that the offense was committed against the person's will. Against her will means that the alleged victim did not consent to being seized, confined, imprisoned, inveigled, or kidnapped. A person submitting because of fear is not a person giving consent. The fourth element is that the defendant so acted while armed with a dangerous weapon. By law, a loaded firearm or loaded rifle is a dangerous weapon. The fifth element is that by means of the dangerous weapon, during the act of kidnapping, serious bodily injury resulted. Serious bodily injury means permanent disfigurement, protracted loss or impairment of a bodily function, limb, or organ, or substantial risk of death. If the Commonwealth has proved all five elements as I've given them to you beyond a reasonable doubt and proved criminal responsibility beyond a reasonable doubt, you may find the defendant guilty. If the Commonwealth has proved the five elements of kidnapping armed with bodily injury as I've given them to you, but failed to prove criminal responsibility beyond a reasonable doubt, then the proper verdict is not guilty, lack of criminal responsibility. If the Commonwealth has failed to prove any of the five elements of armed kidnapping causing bodily injury as I've given them to you beyond a reasonable doubt, then the proper verdict is not guilty in its simple form. The next indictment is a single indictment for aggravated or armed burglary. To prove the Commonwealth must prove six elements beyond a reasonable doubt. First, that the premises were the dwelling house of another. Second, that the defendant broke into the dwelling house. Third, that the defendant entered the dwelling house. Fourth, that the defendant specifically intended at the time of his entry to commit a felony in the dwelling house. Fifth, that the defendant committed an actual assault on a person lawfully therein. And sixth, that these events took place during the nighttime. Breaking into a dwelling means forcing or moving some impediment to entry. If one has a door that is closed, whether locked or not locked, and you open it, that is a breaking of the dwelling, unless it's done permissibly. Entry means crossing the threshold. The actual assault on a person therein, certainly we have discussed what constitutes an actual assault in our prior discussions. That definition applies here. Nighttime is any time after 10 p.m. and before, is it 5 a.m., counsel? I believe it's 5 a.m.
I believe for the burglary statute, it's,
I'm sorry?
for the burglary statute, it's after sunset.
Is it still sunset?
Yeah.
I know for some it changed to 10 p.m.
Right.
In the context of this case, we'll leave it at 10 p.m.
That's fine, yep,
Oh, thank you.
thank you.
Okay. And there is still the element that the defendant, at the time of his entry, had the intent to commit a felony therein. A separate felony beyond the breaking and entering. An assault on an occupant by means of a dangerous weapon would back up. An intent to commit a specific assault on one occupant therein, which resulted in an assault upon a second occupant therein, would be a sufficient felonious intent and assault of the fifth element of an occupant therein. If the Commonwealth has proved all 6 elements beyond a reasonable doubt as I have given them to you, and proved criminal responsibility beyond a reasonable doubt, then you may convict. If the Commonwealth has proved all 6 elements as I've given them to you, but failed to prove criminal responsibility, then the proper verdict would be not guilty, lack of criminal responsibility. If the Commonwealth has failed to prove any one of the 6 elements as I've given them to you, beyond a reasonable doubt, then the proper verdict would be not guilty list form. There is a single indictment for possession of a hoax device. In order to prove the defendant guilty of that charge, the Commonwealth must prove 4 elements beyond a reasonable doubt. First, the Commonwealth must prove that the defendant possessed an item or placed an item in a location. Second element, the Commonwealth must show beyond a reasonable doubt that the item was a hoax, explosive, destructive, or incendiary device. And the definition of a hoax, explosive, destructive, or incendiary device is any device, article, or substance that would cause a person to reasonably believe that such device, article, or substance is an explosive or a destructive or incendiary device or substance. Third element, the defendant knew the item he had was a hoax device. Fourth element, that he acted with the specific intent to cause anxiety, unrest, fear, or personal discomfort in any person or group of individuals. The Commonwealth has proved all 4 elements as I've given them to you beyond a reasonable doubt, and proved criminal responsibility beyond a reasonable doubt, then the proper verdict is guilty. If the Commonwealth has proved all 4 elements as I've given them to you, but failed to prove criminal responsibility beyond a reasonable doubt, then the proper verdict is not guilty by lack of criminal responsibility. If the Commonwealth has failed to prove any one of the 4 elements that I've given you beyond a reasonable doubt, then the proper verdict is not guilty in its simple form. As I instructed you, that 4th element is again what we would call a specific intent. There must have been, in the mind of the defendant, at the time, an intent to cause anxiety, unrest, fear, or personal discomfort in any person or group of persons. As with any specific intent that I have instructed you on, mental disease or defect may be considered in your determination as to whether the Commonwealth has or has not proven that specific intent. The next indictment is a single indictment for assault and battery on a police officer, to wit, Jared McDonald. In order to prove the crime alleged, the Commonwealth must prove 5 elements beyond a reasonable doubt. First, that the defendant committed a touching upon McDonald, however slight. Second, that the defendant intended to engage in that touching. Third, that the touching was harmful or offensive. Fourth, that it was committed without excuse or justification. And fifth, that McDonald was a police officer engaged in the performance of his or her duty, and that the defendant knew McDonald to be such an officer engaged in the performance of his duty at that time. The touching may be accomplished by means of a dangerous weapon. It need not be a physical hand-out to the body touching. It may be an item propelled at the body and touching the body of the victim. It must be harmful or offensive. A harmful touching is one that is physically or potentially harmful. An offensive touching is an affront to a person's integrity. It must be committed without justification or excuse. Clearly, when you get on the subway, you expect to be jostled if it's rush hour. Those touchings are accepted in our everyday society. This touching must be without justification or excuse. Not only must McDonald be an officer in the performance of his duty, but the defendant need know that the person he's touching is an officer in the performance of his duty. If the Commonwealth has proved the 5 elements beyond a reasonable doubt, as I have given them to you, and proved criminal responsibility, you may find the defendant guilty. If the Commonwealth has proved the 5 elements as I've given them to you, but not proved criminal responsibility beyond a reasonable doubt, then the proper verdict is not guilty, lack of criminal responsibility. If the Commonwealth has failed to prove any one of the 5 elements as I've given them to you beyond a reasonable doubt, then the proper verdict is not guilty in its simple form. Yeah. In the pile here, Mr. Clerk, we've got burning a motor vehicle. I seem to have... Oh, I've got it. It's actually the 18th count. The Commonwealth alleges burning of a motor vehicle. To find the defendant guilty of that offense, the Commonwealth must prove 4 elements beyond a reasonable doubt. First, that the property in question was a motor vehicle. Second, that the defendant set fire to the motor vehicle, causing it to be burned. Third, that the defendant did so willfully, that is intentionally, not by accident, not by recklessness. Fourth, the defendant did so maliciously, that is, it was done with some wrong or unlawful motive and without excuse. With regard to burning a motor vehicle, one can burn their own motor vehicle and still be guilty of this crime, so long as all 4 elements have been proven beyond a reasonable doubt. It need not be the motor vehicle of another. Motor vehicle is its common everyday meaning. I need not define it. Likewise, I need not define setting fire and causing it to be burned. That the defendant did so willfully, that is intentional. It's got to act intentionally. Excluding accident. The government has to exclude accident. Maliciously, it's done for some wrong purpose, wrongful motive, done without proper excuse. If the Commonwealth has proved all four elements as I have given them to you beyond a reasonable doubt and established criminal responsibility beyond a reasonable doubt, then you may find the defendant guilty. If the Commonwealth has proved the four elements as I've given them to you beyond a reasonable doubt, but failed to prove criminal responsibility beyond a reasonable doubt, then the proper verdict is not guilty, lack of criminal responsibility. If the Commonwealth has failed to prove any one of the four elements that I've given you beyond a reasonable doubt, then the proper verdict is not guilty in its simple form. Yet again, when one considers willfulness in this context, one may consider mental disease or defect as to whether it does or does not affect willful, malicious, wrongful intent. And again, unless I've slipped an indictment or a charge, I believe that brings us to the final one, possession of a large capacity feeding device, of which there are 10 separate indictments. On the verdict slip, there is a location specified for each of the alleged feeding devices. There are instances where that description is identical for more than one of these matters. For example, the first complaint in that regard, the specification is on the belt, rear deck number 71. The next one thereafter is on the belt, rear deck number 71. The next one after that is on the belt, rear deck number 71. When you're considering any single charge of possession of a large capacity feeding device, the jurors, if they are to convict, have to be unanimous as to that specific device in that specific location. In other words, 6 of you can't say, well, I know you have a large capacity feeding device and I'm fully satisfied at such and such a location, but I don't know if you have one over there, number 71. That's not unanimity. It has to be that device in that location unanimous if there is to be a conviction as to any one or more of those charges. In order to prove its case, its allegation in that regard, the Commonwealth has to prove 3 things beyond a reasonable doubt. 1, that the defendant possessed a specific item. 2, that the item meets the legal definition of a large capacity feeding device. And 3, that the defendant knew he possessed this large capacity feeding device. A large capacity feeding device is a fixed or detachable magazine, box, drum, feed strip, or similar device capable of accepting, or that can be readily converted to accept, more than 10 rounds of ammunition or more than 5 shotgun shells. If the Commonwealth establishes that the defendant had in his possession a particular large capacity feeding device, as I've defined it, and he knew that it was a large capacity feeding device, and the Commonwealth has so proved beyond a reasonable doubt and established beyond a reasonable doubt criminal responsibility, then you may find the defendant guilty. If the Commonwealth has proved the 3 elements as I just gave them to you, but not proved beyond a reasonable doubt criminal responsibility, then the proper verdict is not guilty, lack of criminal responsibility. If the Commonwealth has failed to prove any one of the 3 elements as I've given them to you, then the proper verdict is not guilty in its simple form. There is no minimum, there is no maximum time for a jury's deliberation. You take whatever time you deem appropriate. in deliberations, say between 4 and 4:15. I would appreciate a note from you, Madam Floyd, stating either that we would like to continue today's deliberation or we would like to adjourn. The jury can certainly adjourn, and in this instance, it would be adjourned for the weekend and resume deliberations Monday. That's within your prerogatives. Certainly stay, assuming I can make proper arrangements with my staff. No cell phones, people's PDAs, Blackberries, things that buzz whiz chirp, operate electronically. No. That jury room. Yes, you will survive without them. You'll get them back when you leave the jury room. A jury room is never a place to order a Domino's pizza.
Where's Jim?
And worse yet, never a place to call a loved one and say,
Down.
deliberating, what do you think? Oh, you might chuckle, but I've had that and worse over the years. No communication list. We've banned smoking in this building. If you are of the habit of nicotine, or you're a non-smoker seated next to the smoker, and you can't stand he or she another minute until they've had their cigarette, by all means, call for a smoking break. Those who wish it will allow the court officer, and when they're done, come back in. While you're parked there before lady for that or any other reason, do not deliberate. You only deliberate when all 12 deliberating jurors are around the table. If you reach a verdict, Madam Floor Lady, you check the appropriate box or boxes on the verdict form, you sign it, you date it, and you return as a group into court to announce the verdict. If you reach a verdict, you tell the court officer you have a verdict, and they will set up the court from there. I am always delighted to get a note from you if you have a question about the law or about the procedure. I'm happy to answer such questions. Take a piece of scrap paper, Madam Floor Lady, you write out the question, you sign it and date it, get it to the court officer, how I will respond in writing, or I'll bring you back to the court for further instruction.
Okay.
Don't send me a question about the facts. I'm not the judge of the facts. And I don't have the ability to produce a transcript of this, that, or the other thing on demand. Even if I did, in effect, I'd be emphasizing one part of the evidence over another, and I would not be inclined to do that. You've got to rely on your collective memory as to the facts of the case. Let me see the attorneys at the sidebar, please. Mr. Clerk, do you still attach the copies of the indictments to the verdict slips?
We do not, Judge.
You do not. I assume that's not an issue, counsel?
I'm sorry, Mr. Segadolid asked me a question.
Well, what I was saying was the clerk does not attach a copy of the indictments to the verdict slips.
Oh, then no, that wouldn't be.
Then that's not
Thank
an
you.
issue. All right? Mr. Clerk, you may reduce the jury.
Thank you, Judge. Jurors, time having come for the final submission of this case to you, the jury and the panel of 14 members being present, I'll now place the seat numbers of the jurors in the box, except for the seat number of the 4 person. I'll then withdraw the seat numbers of 2 jurors who will be separated from the jurors in the attendance of the court officers until discharged by further order of the court. Juror now in seat number 5, that's juror number 24. And juror now in seat number 13, that's juror number 87. Each of you are hereby designated as an alternate juror to be kept separate and apart from the other jurors in the attendance of the court officers unless drawn to replace a juror or discharged by further order of the court.
I'm not sure that computes. Madam Forelady, what was your original juror number?
97.
Yeah.
That's right. So,
Okay, so
all
it's,
moved over.
everybody's moved over, so it's juror number 87.
Now in seat number 13.
Now, I think she's in seat, well, it depends on how you count them, I suppose. You're establishing the box as it originally was.
Yes.
Okay. It's juror Olson. You're an alternate. And the other one is juror Lynch,
Correct.
okay? Lynch and Olson are my alternates. The jury is out of the room. Please be seated. Now, Deb, I know that several interested folks just left, family members. Would you please advise them as to my normal rule that I take questions and verdict at any time? There will be an announcement made out in this hall that the court's going in. There'll be an announcement made out the back door that the court's going in, and I assume an announcement on the first floor. That's all the announcement anybody gets. We're not waiting for interested spectators to come back. If you have an interest in the verdict or questions, you've got to be around here. It's that simple. Counsel are not to leave this floor because there can be questions and verdict at any time. And I don't want you wandering around the village. A young lawyer last year made that fatal error to his detriment to the tune of $100 in court costs. I know that's not much for you, Mr. Segadelli, but still, you know. All right, now, I want you to review the exhibits with the clerk, and if you're satisfied, please so state on the record.
I don't know what this.
Now, we're certifying the exhibits.
I'm not taking you on.
Thank you. Thank you.
All right, gentlemen, we'll go through the exhibits. Jim, why don't you, Brian wants to stay by the boards, maybe you can deal with that and I'll deal with this. All right, so exhibit number 1 is a board with 2 photos.
Yes, that's fine, thank you.
83 bullet,
Yes.
84 bullet,
Yes. Yep.
85 bullet.
Yes. Yes.
86 bullet,
Yes.
87 bullet,
Yes.
88 is a chart.
Right here? Yes.
That's formally identification J. 89 bullet,
Yes. Yep.
90 bullet fragment, 91 death certificate copy,
Yes.
92A is a magazine clip.
Yes.
92B is 22 caliber ammunition.
Yes. Yes.
92C, test fire round.
Yes. Yes.
93A is a clip.
Yes. Yes.
93B, 22 ammo.
Yes. Yes.
94A is a magazine clip.
Yes.
94B, 22 ammo.
Yes. .
what was it? 95 is a rifle.
Yep. Agreed.
Make sure. Tag on. 95.
Yep.
95A clip,
Yes.
96. 96.
We don't have a 95A.
Yeah, no, it looks like Tom had it crossed off and then so 96A, 96B, and 96C.
Yes.
Yes.
Okay. 97A is a handgun.
Yep.
Yes.
97B is
Yes.
Yes.
I'm going to throw this envelope out if nobody cares, because
That's
the
fine.
item's marked.
That's fine.
97C is ammunition, 97D is test fire rounds. 98, tactical belt.
Agreed.
Yes.
99A and B, magazine clip and ammunition.
What number are you looking for?
99A.
108, so 99.
Clip, 99B,
Yes.
Yes.
and 100A and 100B.
I got 100A, and I've got 100B.
Yes.
102A. Excuse me, 101A, 101B,
That's 101, right? A and
Yes.
B? Yes. Yep.
and then 102A and B. Magazine. Ammo.
Number 2A?
Yes.
102B.
Yes.
103A and 103B.
Yes.
Yes.
104A and 104B.
Number 4A? Yes.
Yes.
104B. You got 104B, right?
Number 4B? Yes.
That's that ammo. 105 is a board with 6 photos.
Yes.
Peter. $106,
Yes.
unknown
Yes.
fragment. 107, board with 8 photos.
Agreed.
one that's clipped to it, Brian.
Yeah, that's the one, that's
Right, I
Exhibit
have
127.
a clip to that for no other reason than so it wouldn't get all wrinkled, you know. We could put it in a box,
Or I could, yeah.
leave it, or we can fold it and put it in a box.
Oh, it's too big anyways, but yes. Well, we'll wait till we get to it.
Okay. 108 discharged casing.
Yes, yes,
109's discharged multiple cartridges.
yes.
Yes.
110 board, 6 photos.
Agreed.
111 is a magazine.
Yes,
Yep.
112 discharged cartridges.
yes,
113 board with 8 photos.
Joe?
yes,
114 multiple cartridges.
yes, yes,
115 is a spent projectile.
yes,
Yes.
116, I have that here, certificate of examination and test firing.
yes,
117 is a knife.
Yes.
agreed.
118 is a DVD.
Yep.
Agreed.
119 is a CD.
Yep.
120, board with 3 photos.
Yes,
Yes.
121A, letter.
yes,
121B,
yes,
122, board with 9 photos.
agreed.
123, flash drives. Be a bag with,
Yes,
a bag with a bunch of flash drives.
what number are we looking for?
123. Really large.
Agreed, yes,
124, map, directions.
agreed.
125A, GoPro camera.
Agreed.
125B, still flash drive. I have the DVDs. 125C, and then 125D,
Yep.
126A, flash drive,
Agreed.
126B, DVD,
Agreed.
126C, DVD,
Yep.
126D, DVD,
Agreed, yep.
large photo. Is that the,
Here. Sorry.
I'm not sure where you all want to put that. I didn't want to stick in a box if it's going to get.
Oh, we can just put it right here.
That's fine.
Can we fold it? Is this,
Yeah, I don't, I have no objection to both.
Right.
you know, my fold? Okay, so that's 127. 128, book,
Agreed.
129,
Yes,
130,
yes,
131,
yes,
132,
yes,
133, 133A,
Yep, yes,
133B,
yes.
134,
Yep.
135, report, Dr. Kelly, 136,
Yep, yes.
137A, commission order,
Yes.
137B,
Yes.
138, report,
Yes.
139.
Yep, yes.
All right. That should do it, counsel. Counsel, agree you've reviewed the exhibits, and you certify on the record you're satisfied with the exhibits as reviewed.
Would you repeat that, please, Mr. Clerk, for the stenographer?
Counsel, you agree that you've reviewed the exhibits, and you certify that you're satisfied with the exhibits as reviewed going into the jury?
I so certify.
Yes, Your Honor.
And you're certifying the verdict slips as appropriate as well?
Yes.
Yes, Your Honor.
All right, the verdict slips and the exhibits may be taken to the jurors. The court will stand in recess. Counsel, please be available to proofread the transcript of the instruction going to the jury. Thank you.
Yes, sir.